resorted to Rule 76. Rule 76 is only in respect of unauthorized absence for 5 years. Under the with reference to inquiry, you have not imposed the penalty. You are short-circuited the proceedings of disciplinary proceedings and resorted to Rule 76. Rule 76 is only in respect of unauthorized absence for 5 years. Suspension was revoked.
No, nowhere suspension was revoked, and only for the absence.
Wait for a minute. On the other hand, there was no response. In the meanwhile, he was subjected to disciplinary proceedings in framing article of charges on 25/9/2006.
Your Lordship, the punishment is dismissal. Allegation is unauthorized absence. Allegation is unauthorized absence and punishment is dismissal. After a lengthy hearing, Your Lordship, a copy given here. Your Lordship, please stand.
All right, give the list of dates and events.
Yes. Then after a long hearing, Your Lordship located serious infirmity in the departmental proceeding, and therefore Your Lordships, just for the purpose of saving the state exchequer public money, made an offer to them, you convert the dismissal into the compulsory return in the presence of commissioner. And commissioner at that point of time so and appears to be agreeable to my lordship. But last occasion he refused, you shall note.
Where is the dismissal order?
That's dismissal order is Annexure 17, page 7 of IA number 1243 of 2011. IA number 1243 of 2011.
My lord, that dismissal order has also been annexed with the counter affidavit.
I'm referring your counter affidavit. Okay, you do it.
As annexure P, my lord.
Annexure P.
My lord.
Annexure P. Yeah, Annexure P.
Where is your reply to the second show cause?
I did not. Reply.
No, Annexure 10.
Annexure 10, page 27. But your lordship, my basic objection is, can they use Rule 76 in this case? Rule 76 of the Bihar, can they invoke the provision of Rule 76? I was proceeded against only for the absence.
No, from the dismissal order, where is the reference to Rule 76?
In the last line of the dismissal order.
76 of Bihar
Service Code. Niyam, sir. And then your lordship, I will request your lordship to have a look to the Rule 76. Oh. Rule 76 of Bihar Service Code. What does it say? And your lordship, while sitting singly, have discussed the issue in another case, and I have got the order also, whether that can be done. Rule 76. May I read this? Service code.
Suspension was revoked.
No, nowhere suspension was revoked, and only for the absence.
Wait for a minute. This is the suspension. The question of unauthorized absence for continuously for 5 years. Suspended on 13/5/2000 with effect on 17/2000. Thereafter, where is the
Where is the order of suspension?
Suspension order is, my lord,
annexure?
Annexure 3, page 20.
Annexure B at 20, my lord.
Okay.
There be in the counter evidence. Annexure B, page 20. 13/5/2005, he was put under suspension, lord.
This suspension order says.
निकाला अपन मीटिंग निकाला
Headquarters.
Headquarter? No. Suspended employee need not appear in the office. He should be only in the headquarter. That's all. At the best, he is not entitled to subsistence allowance if he is not in the headquarter. That does not amount to unauthorized absence.
How his presence will be checked?
Or he has to,
How?
he has to contact the concerned address. Otherwise, if he is asking for subsistence allowance, he must give certificate that I am in the headquarter for these many days.
I asked for him on 11th.
Huh?
I asked for him
On?
on 11th.
What is
That's the situation.
no.
The employee asked to attend the office.
Read the suspension provision. There is provision for his attendance in the office. His lien may be there in the office. Where was he working as on the date of suspension? Where was he working? In which office he was working? Suspension.
PMCH.
Huh?
PMCH. Medical College Hospital.
Huh. He has been shifted to this office.
They already work.
Correct, sir. Yes. And lien has been shifted to this office.
This officer.
Yes. Office first. Principal of?
PM.
So my first submission is, Your Lordship, the rules, provisions of Rule 70.
You have understood, yes? How do you determine unauthorized absence for 5 years?
But so far as it appears from the annexures, I will find that the departmental posting was initiated on 2 charges. First charge is gross.
But you have not completed the inquiry.
That inquiry has been completed, Lord.
But you have not imposed the penalty.
Penalty has been imposed, Lord.
Where is with reference to inquiry, you have not imposed the penalty. You have short-circuited the proceedings of disciplinary proceedings and resorted to Rule 76. Rule 76 is only in respect of unauthorized absence for 5 years.
I go down to my lord's object. So far, 76 is concerned of the on the ground of that he remained absent for the certain period. That is why I ordered that rule a person can be dismissed. But so far as this instant dismissal is concerned, Lord, the departmental posting has been issued on 2 charges, Lord.
Sir, that is all right, but you have not completed that proceeding.
The process has been completed, Lord.
Where is the final order in a disciplinary proceeding?
The departmental posting has been held.
Where is the final order, penalty order?
Penalty order is, this is the penalty order, my lord?
Penalty under Rule 76, 74 of Bihar Service Code. Where is the penalty order under CCA rules?
On the basis of that departmental proceeding, my lord, the inquiry was held, the inquiry report was submitted, and thereafter the second so-called notice has also been asked, my lord. Thereafter, after receiving,
Thereafter, you short circuited the method of resorting to Rule 74 instead of passing order under CCA rules.
Lord, under the CCA rule, it has been passed, my lord.
No, read the
Reference to that has been,
dismissal order.
only reference to that has been made, but the
Then have you modified this? Withdrawn, cancelled, modified. That his dismissal is under CCA rules and not Rule 74 of Bihar Service Code.
so reference to, but a full-fledged inquiry has been held, my lord.
We do appreciate, but there is no finality. You are not passed final order under CCA rules.
Prior to passing final order, my lord, even the concurrence of the BPS has also been obtained, and then and only this final.
Then we have to congratulate you. Everything is done except passing final order. In the final order, you have resorted to 74. Why?
Great apology, I submitted, Lord, that a final order has been passed, Lord. Of course, Lord, a reference has been made to that, but on the basis of the departmental.
You can't say that it is a typographical error or a mistake for the reasons that dismissal could be resorted under two provisions of law, one under CCA rules and another is Bihar Service Code.
Under CCA rule, this dismissal has been made, not under the Bihar Service Code, widow. Under CCA rule, this department.
That's all. Now he is no more, you can't take any action also. That is the reason last occasion we have suggested in order to save some money to the state of Bihar to convert the penalty of dismissal to that of compulsory retirement.
My lord, as per his writ of own case, my lord, from paragraph 9 and 10 of his writ of petition, it is evident that without leave he remained from India, my lord, in the year 2005 and
All right, sir.
2010, lord. It is
We'll consider.
for admission, lord.
Consider. Yes, take on.
Lord, may I take leave?
Huh?
May I take leave because one,
Yes.
my junior agent.
State on in the instant petition, petitioner has assailed, LPA. Appellant has assailed the order of the learned single judge date 18/1/2017, passed in CWJC 13559 of 2010. The Dr. Arun Kumar Prasad, while working in primary health center,
PMCH, Patna Medical College. The post of assistant professor, neurosurgery.
in the post of assistant professor, neurosurgery department, he had committed alleged misconduct of remaining unauthorized absent for which he was placed under suspension on 13/5/2005 while giving effect from 17 to 2005. 7 to 2005. Full stop. He had reported back to duty on 16/7/2005. Full stop. He had requested for a leave on 11/7/2005. Thereafter, there was an inaction either accepting or rejecting. There was a press notice on 14/1/2006 for which the petitioner had, appellant had responded requesting for leave. Thereafter, there was an inaction on the part of the state. To stop. Once again on 16/3/2006, petitioner once again submitted a leave application. On the other hand, there was no response. In the meanwhile, he was subjected to disciplinary proceedings in framing article of charges on 25/9/2006. And it was concluded in imposition of penalty of dismissal from service. On 4/11/2010. In the meanwhile, leave application was rejected on 10/2/2009 after a lapse of about 3 years from the date of his initial leave application on 16/3/2000. 11/7/2005, 16/2006 and 12/5/2008. During his suspension, he had gone abroad, namely Mozambique, MOZAMBIC, and returned on 21/1/2010. Reported for duty. However, his duty report was not accepted. Next one. The petitioner, appellant, feeling aggrieved by the dismissal order, filed CWJC 13559 of 2010 to one single judge proceeded to affirm the order of dismissal. While appreciating the factual aspect of the matter, that deceased appellant remained unauthorized absent and had gone to abroad. In this regard, Ran Singhal has taken note of decisions in para 17, 22 24. Further, one single judge has imposed a cost of rupees 20,000 so appealing agreed by the order of the learned single judge. Appellant has, deceased Dr. Arun Kumar Prasad filed LPA. During pendency of the LPA, he has died and LRs have been brought on record. If learned counsel for the appellant submitted that in the order of dismissal, there is a reference to Rule 76 of BR Service Code. In the event of invoking the Rule 76 of BR Service Code, one of the criteria is that an employee must be under unauthorized absence for more than 5 years. It is submitted that deceased appellant was not remained unauthorized absent for 5 years so as to invoke Rule 76 of Bihar Service Code. Even though disciplinary proceedings have been initiated and it was almost in the final stage of issuance of show cause notice, and second show cause notice was issued on 1/3/2005/1/3/2007, for which deceased had filed his reply on 12/4/2007. However, imposition of penalty under CCA rules has not been resorted. On the other hand, Rule 76 of Bihar Service Code has been invoked. Which is contrary to factual aspect of the matter, and the same has not been appreciated by the learned single judge. It is further submitted that the aforesaid submission is a legal issue which is required to be considered by this court. Next, per contra and counsel for the respondent resisted the contention of the petitioner and submitted that there is no impunity in the disciplinary proceedings initiated against the appellant, a deceased appellant, and so also order of dismissal passed under Rule 76 of Bihar Service Code. So also order of the learned single judge. At this juncture, learned counsel for the state submitted that Rule 76 quoted in the dismissal order may be by mistake instead of quoting the CCA rule. Therefore, impugned order of dismissal is to be treated as passed under CCA rules and not under Bihar Service Code. To stop, heard the learned counsels for the respective parties. Deceased Dr. was a responsible citizen of this country, who has been assigned the duties of the post of assistant professor in the neurology department PMCH. Abruptly, he remained unauthorized absent for some period, and the same was noticed by the disciplinary authority and proceeded to dismiss him from service. Placed him under suspension on 13/5/2005. Thereafter, he was subjected to disciplinary proceedings in framing article of charges, and it was concluded in imposition of penalty of dismissal from service under Rule 76 of Bihar Service Code. Ordinarily, court will not interfere in respect of disciplinary proceedings on merits. In other words, time and again, courts have held that writ court or any other court cannot sit over as an appellate authority. Therefore, we are not considering anything on merits. We are restricting to only legal issues involved in the present case. It is necessary to reproduce dash rule CCA for placing under suspension. You have to extract that rule. CCA rule. And it is also necessary to reproduce Rule 76 of Bihar Service Code, which reads as under. Reading of the aforesaid provision of suspension, it is crystal clear that temporarily there is a seizure of a relationship of employer and employee if an employee is placed under suspension. Therefore, master and servant relationship continues while he was under suspension. It is also to be noted that while an employee or a government servant is placed under suspension, he need not attend the office on daily basis and on day to day. Therefore, the intervening period from the date of suspension, that is 13/5/2005 till imposition of penalty of dismissal from service on 4/11/2010, cannot be treated as a unauthorized absence. The question of unauthorized absence of a government servant or an employee would arise only as and when he was in service. In other words, he is discharging the duties of the post. On the other hand, in the present case, deceased officer was placed under suspension. In other words, he was prevented in attending the office. Therefore, one cannot draw inference that he remained unauthorized absent for more than 5 years during the intervening period from 13/5/2005 to 14/11/2010. This point has not been taken note of by the learned single judge. Next paragraph. Further, it is noticed that deceased employee was placed under suspension on 13/5/2005 with effect from 7/2/2005. There cannot be a retrospectively placing an employee under suspension. The relevant rule does not provide to place an employee or a government servant under suspension from the retrospective date. Similarly, while passing the order of dismissal on 4/11/2010, deceased employee has been dismissed from service with effect from 7/2/2005. Concerned respondent is not permitted to place a government servant or an employee under order of dismissal from retrospective, since CCA rules or Bihar Service Code do not provide for imposition of penalty of dismissal from service retrospectively. Next paragraph. Assuming that placing him under suspension from retrospectively is treated as prospectively and it is curable. Similarly, punishment of dismissal from service with effect from 7/2/2005 is also curable, treating the order of dismissal with effect from 4/11/2010, still imposition of penalty of dismissal under Rule 76 of Bihar Service Code is contrary to the criteria mentioned in Rule 76 of Bihar Service Code. Next, in fact, on the previous occasion, we have suggested to modify the penalty of dismissal to that of compulsory retirement with effect from 7/2/2005, the date on which he remained absent, read with the suspension on 13/5/2005. However, the suggestion made by us was not acceptable to the state government, whereby we were compelled to pass orders on merit. It is a case for remand to complete the inquiry proceedings with reference to second show cause notice dated 1/3/2005/1/3/2007, read with the reply of the deceased employee dated 12/4/2007, while invoking relevant provision of CCA rules. However, question of remand to the disciplinary authority is not warranted for the reasons that assistant professor dash deceased doctor is died during the pendency of the litigation. Therefore, question of remanding and asking the disciplinary authority to pass the order in terms of CCA rules is impracticable. Next up, in the light of these facts and circumstances, The appellant has made out a prima facie case so as to interfere with the order of the single judge dated 18/1/2017, passed in CWJC 13559 of 2010, and it is set aside. In the result, order of punishment of dismissal dated 4/11/2010, which has been given effect from 7/2/2005, is set aside while allowing the writ petition filed by the deceased Dr. Arun Kumar Prasad. The next part, the concerned respondent is hereby directed to extend all monetary benefits which are due to the deceased Dr. Arun Kumar Prasad and legal heirs are entitled to monetary benefits. The same shall be settled within a period of 3 months from the date of receipt of this order.